We'll finish this chapter, then I'll give you again a break of 10 minutes because I think it is required. Then we'll proceed further with minimum wages act. Okay, beta. So let's go ahead with further provision. Now section 13. So we have done with till section 8, right? Now section 13, maintenance of registers and records. Now, can you tell me what kind of registers they would ask you to maintain? I think they would ask you to maintain the records of timely payment of wages, right? Right? What kind of register it would be? You have to put the names of all the employees, taking signature of that employees if you are paying by check or by cash, and no such records need to be maintained when you are making the banking payments, right? Digital payment, digital record can be classified as a valid record, right? And these records need to be preserved for a period of 3 years. For how many years you need to preserve it, beta? For 3 years. So is it something very complicated? No, right? Right, students? Claims and penalties. Should we proceed further? Section 15. Now they are saying that this law is being formed, they are framed by whom, beta? That is Parliament of India, right? Who made this law, beta? Parliament of India. Means Parliament of India has adopted it. But who is implementing this law? State government, right? Who is implementing this law? I told you very clearly, all labor laws are being passed by Parliament of India, but they are being implemented and rule making powers are being given to the state government. So it is going to be vary from state to state. So tell me who is going to appoint the executive authorities like inspectors, court or officers under this act? The state government, right? Even a local police officer can be a labor officer, right? A labor inspector, right? Because state functionaries are going to implement this act, right? Right, students? So if can a police officer inspect the records maintained under this act? Tell me, yes or no? Can a police comes under what? State government, right? Who is appointing police, beta? State government, right? Not the central government, right? So can a sub inspector can act as a labor inspector under this act? Yes, he can be, right? So state will determine the state functionaries, right? So here they are saying that the appropriate government can appoint specific officials to handle claims related with deductions and delays, right? If you are have any complaint related with payment of wages act, to whom you are going to approach? You are going to approach the central government or the state authorities? You have to approach the state authorities. You cannot approach the central government because this law is being implemented by state government. So they can appoint workmen compensation commissioner, they can appoint regional labor commissioner, they can appoint assistant labor commissioner, they can appoint presiding officers, they can appoint any judicial magistrate as well. So these authorities can be appointed as a functionaries by the state government, right? Right, students? You can file claim with them. And if the work burden is high for one single area, the state government can appoint multiple authorities. Is it clear? Is it clear, students? Section 13 is you have to maintain certain records and those records need to be preserved for a period of 3 years. The second, section 15 stating that what? What section 15 is saying? That this act is being adopted by the Parliament of India, but the functionaries and implementation will be taken care by the state government. So state government can appoint commissioner or certain relevant officers or magistrate, appointed under different law to act as a functionaries under payment of wages. Any person who is aggrieved by employer can file a complaint with the state functionaries, not with the central government. Got my point, students? Now application for claim. Should we proceed, student? Application for claim. Here, who can file the claim? The employed person himself can file the claim, okay? A legal practitioner or a representative of a registered trade union can file the claim. An inspector who find that certain wrong thing has been done against employee can file the complaint. A person appointed by the authorized authority can file the complaint. Complaint can be filed within the period of 12 months. Within how many months you can file the complaint, beta? Within. Now, suppose an employee, certain employees of an organization is approaching me and saying that, Rahul, it's been last 6 months, they are not paying us on time. It has been happened so many times with so many distressed organizations, right? I know many organizations which have not made the timely payment, but employees due to repo with the employer is generally suffering. It's okay. See, abhi many airlines has came out with layoff policy, right? Google has came out with layoff policies. Facebook has came out with, Meta has came out with layoff policies. So if you are laying off employees, or if you are retrenching employee, you are liable to pay them the compensation within 2 working days, right? So how these things will be, happen in real life? Like they'll start dragging the payment of undesired employees, right? They'll not make the payment on time. They'll, humiliate them. They would, exploit them. So employee will take care, bear the burden for a period of say 3 months, 4 months, 5 months, and afterwards they'll approach or go for a legal action, right? And they are saying that Rahul, they are not making payment on time, and we are very much worried that how we should proceed further. So I would say, being a practicing CS, although I am also eligible to present their case in the labor courts, but I would suggest them go for a lawyer who is well equipped with the local labor laws, right? Because here the understanding of local rules are quite very much important rather than understanding the national law, right? Because it is not just the matter of payment of wages act 1936, but it is a violation of local rules as well, right? So to whom to approach is going to be determined by the lawyer, whether it would be magistrate or labor commissioner or inspector. To whom you have to approach is going to be according to the state rule, right? I would suggest them, when the first default has been committed, you have to file an application within the period of 12 months. Within how many months you can file the contravention, beta? 12. Understand this point. Suppose they have defaulted on payment in July 2024. Being an employee, I can file complaint till July 2025. If I'll make it delay and I'll approach the court by August, September or October 2025, court will ask me that why the delay is being caused, because there is a limitation period, right? What period is being imposed, beta? Limitation period, that any complaint under this act can be filed only within the period of 12 months, not more than that, right? Right, students? Now now they are saying that if delay is more than 12 months, you have to justify the reason for delay. Okay, students? And after hearing, a proper compensation will be awarded. Okay, students? So what we have studied is, the first provision that we have studied is, being industrial establishment, I have to maintain certain records. I have to maintain 2 sets of records. First is for fines, the second one is for regular payments, right? All the records kept under this enactment need to be preserved for a period of 3 years. The next further thing is what? If any employee is a subject matter of, victim of this enactment, right, of the violation of the rules of this enactment, can approach the local authorities, right, established by the local government, bole to state government, right? They can approach the case through any legal practitioner, or they can approach their case directly by themselves, right? They can represent themselves, right? The case can only be filed within the period of how many months, beta? 12 months, right? Delay, if caused, can be condoned, but subject matter of justification, right? Go through once. Tell me the sections, students. The first section was section 1, applicability, quite manageable, and what you are going to resolve by reading this act, you know very well, right? Section 2 will make you very clear that who is employer, who is employee, what do you mean by wages, and on which industrial establishment this enactment is going to be applicable, right? Section 3 is what? Who is ultimately responsible for the payment of wages. 4 is what? What is wage period, right? The 5 is what? When, what is the due date? What is the due date? What is the due date? 6 is what? Mode of payment of wages, right? 7 is what? All 10 deductions are allowed from wages, right? Section 8 is what? Certain rules related with fine, right? So then 9, 10, they haven't covered, right? Straightforward, they came to section 13, right? 13 is what? Record keeping, right? Then 15 is what? How to make the claim, right? How to make the claim. She'll explain. How to make the claim. You are not in the class. Are you in the class? Prove. How to make the claim.
Like who can make the claim or according to what party?
Very nice. Who can make the claim?
Like leading party.
Okay. Means an employer can make the claim, right?
No, the
Can an employer make the claim? Can an employer makes the claim? Generally, the claim would be filed only by the employee, right? That my wage payment has not been made on time, right? Unnecessary fines has been imposed on me, right? Unnecessary deductions has been done, right? These kind of claims will be filed. So who would file the claim? The employee. If he is died, then he is legal hire. If he is incapable, then he is legal representative, a legal consultant, right? Right? Or any other person duly authorized by the authority to present the case. It can be a public interest litigation as well. No, right, students? Right? If the claim has been filed, claim need to be filed within how many months? 12 months from the date of event happened, act or omission, right, by the employer, right? 12 month is what? Limitation period. What kind of period it is, beta? Limitation. Right? What if I'll approach the court after 3 years? Like, you have to verify. Can the court would have an autonomy to, condone the delay? Yes, they are having, right? It is a discretionary power of the court, right, beta? It is the discretionary power of the court, right? And the last one is what? Last one is what? If you will file up C, if you will file the claim, do you think that the court is going to give an ex parte decision, or court will organize a hearing with the employer as well? Tell me. Logical, right? When you cannot impose fine, right, unilaterally, then how they can pass an order against the employer without giving a reasonable opportunity of being heard to him, right? Matlab, it is going to be a bipartite process, not a ex parte process, right? Right, students? Now they are saying that any such issues need to be resolved within the period of 3 months. Within how many months it need to be resolved, beta? Within 3. Means if the claim has been filed on July, August, September, by 30th September it will be resolved, right? Means not only filing claim will have a limitation period, even resolution is a fast track resolution, right? Right, students? But if you want to extend that 3 months, it requires both the parties ka mutual agreement, right? Right? That 12 month can be extended with the approval of the court. But this 3 months require mutual consent of the parties. Got my point, students? Now, what penalties will be imposed upon you? See, here they are saying that they can, if the unnecessary fine or amount has been deducted, they can charge 10 times of the fine imposed, but maximum up to 3,000. Means how much penalty will be imposed on the employer? Whatever unauthorized amount you have deducted, 10 times of the same, or 3,000, whichever is lower. Maximum up to 3,000, not more than 3,000, right? Now they are saying that if you have made delay in payment of wages, 1,500 to 3,000. Okay, on imposing unnecessary fine, how much amount will be charged, beta? 10 times or 3,000, whichever is lower, right? And on delay in payment of wages, 1,500 to 3,000, right? And if you will pay the wages on time, means before the disposal of the case, maximum 2,000. Got my point, students? Is it clear? Is it clear? Fines they haven't asked yet, but still, if you can remember, that's good. If you cannot, just remember that monetary penalty will be imposed. No imprisonment is there. Can I say that, students, if no imprisonment is there, then you can settle this offense with the employee as well, right? Right? See, Have you ever heard about the term compounding? What is compounding? That is settlement of offense, right? When you have done something unintentionally, without any motive, by mistake, right? You can approach the authority and you can ask or request them. See, it is being committed. It is being committed by default. We haven't done anything intentionally with mens rea or guilty mind. Please forgive us and charge nominal compounding charges, right? So all the penalty over here is what, beta? Monetary penalty. And monetary penalty can only be settled. Imprisonment cannot be settled, right? You cannot kill someone and demand for compounding, right? Because it is a subject matter of imprisonment, right? But if accidentally someone has been killed, है ना, in that situation you can seek for what, beta? Settlement, right? Because it's not been an intentional crime, right? Got my point, students? Is it clear? So what we have studied is, now further they are saying that section 15 again. Section 15 states that if someone is victim, he can represent his case to the state authorities, logical state authorities, which can be a labor commissioner, which can be a magistrate even, right? But remember that you have to file the case within the period of 12 months from the date of wrong done to you, right? The fine imposed on you, the delay in payment of your wages, or whatever wrong that has been done against you, you have to file the complaint within the period of 12 months with the state functionaries, right? Once the complaint has been filed within the period of 12 months, it would be automatically accepted, right? If it is being delayed, you have to justify the delay, right? And the last thing is what? Once the complaint has been filed, it will be resolved within the period of 3 months, that can be extended with the mutual consent of the party, right? And in case of the entire process would be a judicial process. Employer will be provided with reasonable opportunity of being heard, and monetary penalty will be imposed upon him. Only monetary penalty. If you will write just a monetary penalty, even I will give you a marks, right? Because I know that you understand that no imprisonment provision is there, right? Right, students? Is it clear? Now the what is monetary penalty? In case of unnecessary fine, 10 times or 3,000. In case of delay in payment of wages, 1,500 to 3,000 for each event of delay, right? And third one is, if you will make the payment before settlement of the dispute, 2,000, right? Right, students? Is it clear? Now, if delay is due to bona fide error or dispute, logical. If the delay is caused due to bona fide error, there is some banking strike is going on, or some other thing which is beyond your control is going on. Is it an intentional default? No, it is a bona fide default. So if the default is bona fide, certain exceptional circumstances are there, okay? When there is problem on the part of employee, not the employer, then employer would not be penalized. Got my point, students? Logical, right? Right, students? If the employee will file the false claim, okay, then 375 will be imposed on the employee, okay, for wrong claims. And if the employer if the employer will do something, 375 will be charged upon him. Just a nominal penalty of 375 rupees, right? Right, students? Manageable hai? Is it manageable? Repeat karte hain from 13. What is 13? Registers and records, or two kinds of registers need to be maintained. The first one is fine related register. The second one is payment related register. Need to be preserved for the period of 3 years. You can preserve it physically, you can preserve it digitally according to the state rules, right? The next one is what? Now the state will determine who is going to be the judicial authority under this act. It may be a labor commissioner or a normal magistrate as well, right? Once the complaint can be filed by the employee who is a victim of delay in payment, victim of unnecessary fine, victim of unnecessary deduction. He himself can file the claim, his legal hire can file the claim, legal representative or any other legal representative or legal officer can apply for the claim. Claim need to be filed within the period of 12 months. 12 months would be counted from the date of wrong done, right? That can be extendable with the reasonable cause, right? the process will be judicial. Both the parties should be provided with the reasonable opportunity of being heard. The next one is what? Monetary penalty will be imposed, right? Any matter filed with the judicial authority will be a fast track matter and will be resolved within the period of 3 months. That can be extended with the mutual consent of the parties. The last one is what? For bona fide mistakes, for emergency situations, and for any mistake where the fault is being committed by the employer will not be responsible, right? Right, students? On employees, maximum penalty is 375 rupees, right? And delay in paying the compensation by employer would also attract penalty of 375 rupees on the employer, right? Right. Now the last question is, do the contract employee would covered under this enactment? Yes. If the contracted employees are working in industrial establishment, they would be covered under this. But the primary liability to pay the wages would be of contractor, not of the employer. If the contractor failed, then the employer is liable to pay the amount, right? Right, students? Is it clear? Everything is clear? Now see, I have made 3 important cases, right? Then 3 newses are there related with payment of wages, right? And all past year questions, which is just a direct question. That is why I have put just the link that all past year questions are here. Is it clear? Right, students? This you can go through with as a story type. You need not to learn the case laws, okay? Newses I am telling you. See, a recent case, date 12th Febco, this order has came out by Jammu and Kashmir court, where the contractor failed to pay the wages on time to the contracted labor. Who would be ultimately responsible to pay the wages is employer. Right? If the contractor will fail, who would held responsible is the employer. See, the J&K court has ordered that if the contractor failed to meet out his obligations pertaining to payment of wages act, it is the employer who is ultimately responsible to pay the wages to the there would be a dispute between contractor and employer. Sort it out later on, but don't drag the employees in this matter, right? Right, students? Now, Allahabad court. Now here it is being clearly written that we have studied that if you are unhappy under payment of wages act, like you are being imposed with unnecessary fine, you are being delayed, your payment has been delayed and all, right? You can approach whom, beta? You can approach the labor court, right? Who is appointing the labor court? State, right? And state appointing any labor court or any officer? Officer means only an individual is being appointed as an court, right? So if an individual is being appointed as a court, right, as an officer, will he be treated as a court? Answer would be yes. The judgment passed by that individual officer will be treated as judgment passed by a court. It doesn't matter whether it is a permanent office or it is a temporary office. That single individual will be classified as a court. Got my point, students? This is being pronounced by whom? Allahabad court. Got my point, students? Is it clear? Now one more case is there. I think Delhi government has came out with this rule that all the payment in Delhi can only be now the digital payment. It cannot be cash payments. Got my point? Means section 6 has been overridden, right? By the state rules, right? Right, students? Manageable? Done with this chapter and the past year question. I don't think it will open. You can open it and you can check over your mobile what kind of questions it is being asked. Check and let me know if you are having doubt fast.
So the Allahabad court order, is that applicable only for that or
For every means anybody can now take the reference of this order and say that I am the court, right?
Basically, the person is going for appeal to Allahabad, district court.
See, an individual officer has passed an order against employer that you have to pay the penalty, and that employer is approaching the Allahabad High Court and asking that
Court or district court, sir?
district court that this is the single officer, how he can act as a court. So they have passed an order that it will be treated as what? A proper court, although he is an individual. Is it clear?
Basically, they are creating an hierarchy.
Yes, yes,
Before
yes.
district court, we can go to the officer.
Yes, we have to ultimately go to officer only. If you are not satisfied with officer and you are approaching the upper court will deny your appeal, right? Go through once online, students, and if you are having any doubt, feel free to ask. Okay? Go through with those questions. I told you to open that link.
Actually, the network is a little weak inside.
Okay. So all the direct questions has been asked. State government has prescribed that now all the entities located in Delhi has to make digital payments. They cannot make cash payments. Who is rule making authority under this act? Who is rule making authority under this act? Who is making the rules under Payment of Wages Act? State. So that is why Payment of Wages Act varies from state to state. Karnataka government may have different Payment of Wages Act. Maharashtra government may have different Payment of Wages. Although these things will be uniform, but when it comes to rule making power, it lies with state government, right? Online students, please interact, and if you are having any doubt, put it over here in chat box. So tomorrow we'll conduct a kind of role play where one would become a practicing company secretary, another one would become what? The employer, and the another one would become employee, and you will have to guide the concerned person that how to deal with that matter, right? Right, students? This way it will work out, right? So should I take it like you all guys have done with Payment of Wages Act, right? Now you are okay with any test to be conducted tomorrow, right? Written test on Payment of Wages Act, right? Right, written test now 5-10 minutes, right? I'll give one question and you have to write the answer, right? Right? So what you have to do, you have to come up with quick revision notes, right? There is no assignment as of now. I haven't given any assignment, just I have told you to go through with those cases, 3 cases that I have not covered in the class. Third, go through with past year papers from that link, right? So that you can have idea that what kind of question has been asked, right? And prepare a questionnaire. Okay, try to prepare a questionnaire that what kind of question a businessman or what kind of question a troubled employee would ask to a consultant when it comes to Payment of Wages Act, right? Can you create a kind of questions, general questions of one liner, right? That when to make the payment of wage, right? That would be the bigger question. Can I make the payment of wages on 2-month basis or 3-month basis or 4-month basis, right? Can a wage period be more than a month, right? It can be, can I pay wage in Delhi in cash, right? Can I make a payment of wages in kind, right? In kind means I'm not going to pay you the wage, I'm giving you mobile phone, or I'm giving you a laptop, or I'm giving you grain, right? Grains, that keep this and take it as a wages, right? Can I do it, right? These all kind of questions. Can I impose fine? Can I impose any amount of fine? Is there any limit on imposition of fine? Can I collect the fine on installment? Can I collect the fine next year, right? These kind of questions can be asked, right? Then if the fine has been imposed, to whom I should approach, right? If something wrong has been, continuously having been done by my employer, to whom to approach, right? Can I am scared about court and the procedure, can I approach through a attorney or agent, right? If I am approaching, what would be the fees or causes or cost would be involved, right? How much maximum penalty can be imposed on employer? How much imposed if I am filing the false claim? Will it be any legal consequences upon me, right? Right, students? So think from the perspective of layman, right? कि वो आपसे क्या वो आप if you will suggest a layman with the reference of law that see I am teaching you Payment of Wages Act, will he sit in front of you? No, he just wanted a solution of his problem. You have to resolve the problem in layman's language, right? Right, students? So done with this. Now after break, I think hardly 45 minutes will left, so we'll cover up the Minimum Wages Act, right? So giving you the break, okay?